Well, hello, and welcome back to the Bold Vision podcast. This is episode 9, and we're here to spotlight bold leaders, game changers, and business owners who are pushing the envelope and making a real impact in the industry. I'm your host, Sonya Sanchez, founder of the Bold Vision SEO, and a firm believer that when we share knowledge, we all rise. On this show, we have real conversations that matter, covering everything from marketing and growth to legal protections, operations, and leadership. So, whether you're a contractor or a service provider or a small business owner, this podcast is here to help you scale with confidence and clarity. Today, I'm incredibly excited to welcome Brandon Davis, a seasoned attorney who brings decades of experience helping small businesses, contractors, entrepreneurs, and any business owner navigate the legal side of growth, something far too many overlook until it's too late. So today, we're going to dig into contracts, red flags, protecting your business, and even Brandon's take on AI tools like ChatGPT and whether small businesses should be using them to create legal documents or not. This is one of those conversations that you definitely want to save and watch later. So let's dig right into it, Brandon. And thank you today. I'm so glad to have you on the show. Welcome.
Thank you, Sonia. Pleasure to be here. I really appreciate not only you helping me at my little presentation to 1 Million Cups, but inviting me onto the podcast as a follow up.
Great, great. Yeah, I'm glad we got to connect. So, why don't you just tell us a little bit about yourself and, how you got involved in, even wanting to become a lawyer, and then we'll just go from there.
Sure thing. So, a little bit about myself, just the basics. I practice under Brandon Davis, attorney at law. I'm licensed in Virginia and Washington, D.C. I've supported everything from software as a service and government contracting all the way through to international oil and gas and construction. So, pretty well exposed to a little bit of everything. As for what drew me into being an attorney, I think like every kid, he was a bit of a jerk growing up. They were told they would make a great lawyer because they like to argue, fight, and be combative. And then I went to law school and found out it's full of those kind of people. I originally went because I wanted to be a family attorney, just based on some things in my background. And quite honestly, once I got out, I had bills to pay. And that's when I found government contracting and the corporate side of legal practice is the quicker path to do that. So that wound pushing me into an area of work where I really got immersed from everything from the employment and labor side, contract negotiation, best practices, and found a way to ingrain myself in organizations to not only get my paycheck, but to actually earn it every single juncture where it's not just compliance is a problem, an attorney a lot of money. It's no, help transform organizations to make compliance something that's built into what they do rather than something that they have to respond to.
Right. Well, that's great. And so, how long have you been an attorney now?
So I was licensed in Virginia in 2019. Having said that, I think everybody values when you graduate with a JD that you can kind of answer most of these questions. And of course, you always buttress that with I'm acting as a paralegal. If you have any questions, check this against an attorney. But you're good enough to at least lead people where they need to go to reduce their legal bill down. Yeah, licensed in Virginia in 2019, waived into DC in 2022.
So, the first thing I wanted to talk about is, contract structures and how to protect your business, basically, on the residential focus. The danger of a handshake deals and contractors versus, written contracts. So let's just talk about if a business owner is going to be working for someone, what is it that they should be doing first and foremost?
Yeah, so the basics for any kind of contract in law school, they teach you it's offer, acceptance, consideration. And then they also teach you statute of frauds. It says if a transaction's over a certain amount, it needs to be in writing. And then there's some exceptions. But really just covering down on the first end of get a simple contract that you can get together. That's anything from kind of a light touch service agreement that covers down on your standard way of doing business. I always say the worst thing you'll do is accept somebody else's paperwork because they didn't care about you when they sent it and they're not going to care about you when you negotiate it.
Hmm.
But by all means, foundations to any contract, particularly in the space that we're going to talk about later, and honestly, in everything I've done professionally, clear definition of the scope of work and clearly define what success and failure actually looks like. So many companies sit down to say, oh, we'll accomplish this goal. And they never actually define what that goal looks like, what the goal standards have to be. And then I wind up in these negotiating out disputes of, okay, well, the client understood this to mean 1, 2, and 3. I only was offering to deliver 3, 4, and 5. now I've got this disconnect where I've got an unhappy customer and I have a potential dispute on hand. And then, God forbid, the scope changed during the course of the contract. So, really, at the end of the day, I think as far as the structure question, it's have something that is adaptable enough to what you're doing, but also comprehensive enough to make sure you're not leaving anything out because you want to make business flow without getting too bogged down in an overly cumbersome document.
Right. So, I mean, I know, I don't know, how familiar you are about, construction projects, but it never goes as planned. I mean, there's always something that's going to arise. And so when, they're writing these contracts, I mean, having a fixed price or allowances or exclusions, I mean, how do you make sure that, you have the ability to make a change if something does come up? Let's just say, even it could be simple as a deck outside, and then, you go to dig and you find that there's electrical lines or, utility lines or something that's going to prevent you from doing the work exactly as you had anticipated. So, what should be written in these contracts to make sure both parties are covered?
Yeah, so two things on that. You would always want to make sure you're checking out for any time is of the essence clause because, like you said, in construction, you're going to find things power lines, water mains, everything. In my town, where they're actually doing a lot of construction, I mean, they're pulling up the road to try to do some of these grading projects. And next thing you know, they're finding out we have laterals that are out. We have maybe knocked a water line that now needs to be fixed. So one of the ways to mitigate that sort of thing is you build in almost like your insurance against the time is of the essence. That says, hey, by this date it's done or the contract is going to have problems. You build in either a contingency amount or you shift the burden and state if these, here are our assumptions. I always say put your assumptions in your proposal, integrate your proposal into your contract, because if my assumption gets upended, now by definition we have a contract change or we have a schedule manipulation that I'm no longer accountable for because things happen. The other thing that I don't think gets enough attention, designate key points of contact who can approve a deviation. The one thing you're going to have if I find something on site and I don't know who I have to go to, or it's got these other kind of layers to run through, if I have a designated person who can commit the organization and I have one belly button, it's an old military thing, give me one butt to kick,
Right.
not 12.
Right.
If I have that one butt, okay, now I've designated the person. Maybe we go to the contract and we say, here were the assumptions. This was supposed to have been done. This needs to enlarge the contract. I have full rights to do that and push it.
Okay. All right. I mean, that sounds good. It sounds easier said than done sometimes, depending if you're working in residential or commercial. I mean, in a residential, situation, most likely you're dealing with the homeowner themselves. But, when you get into commercial contracts, that can be pretty sticky because, depending if it's federal or if it's private will depend on, how many project managers, how many, superintendents, how many entities are involved. And so yeah, it's always good to have a direct point of contact that you can talk to and then, be able to relate that information to find out, how you're going to go forward and to get a direct answer. I know me being in construction for as long as I was, sometimes waiting for answers. You put in an RFI and you just wait and wait and wait and wait. And even if you did have the right person, sometimes just depending on who your client is, will depend on how long you have to wait. So,
Yeah, and change order clauses are so big in that too, where, I get it. There is a bureaucracy to it, right? But and that's on the service provider too, to jump in and say, okay, clearly I've got something that's outside scope, or maybe we have a deviation here. It's you almost have to use the threat of I have to issue a stop work so we can actually fix this problem. And that's having worked in government contracting, right? I have something kind of go off to the side, and next thing you know, okay, I'm kind of sprinting to the finish, trying to sprint to this to get done. So I've got to get their attention with a carrot and stick situation.
yeah. All right. Okay. Well, let's just talk about the commercial GC angle for just a minute. Because a lot of commercial, contracts are going to be an AIA contract. And, that's going to involve like payments and that. So what's one contract clause you see missing most, in a contract? Is there anything that just comes to mind that should, is a clause that really maybe gets overlooked every once in a while?
Honestly, one of the most overlooked ones I see is kind of tackling those indemnification provisions and things like that, where you kind of see them, they drag on limitation of liabilities. Um, but Maybe for a unique bend on this, I'll say it's management and ownership of your subcontractors is probably one of the biggest ones I see to be a problem, particularly when you're adding certain things on kind of after the fact, because it's one thing to maintain your independent contractor status and the kind of left and right lines. The other problem becomes when you're now starting to be accountable for your subcontractors and they expect you to flow down insurance requirements. So always really vet those flow down requirements. One, because they might not be practical, but two, in your sales contract, 99.9% of the time, you're accountable to the client when already. So I don't need to burden my subcontractors because if I have to fix those contracts, I have to pay them or give them something to modify these things into the contract. So I always push back on those negotiations and simply state, you're opening me up to liability. So I'm either going to pass that charge on to you for making me do that, or you can accept that I'm liable to you. So that's where the indemnities and insurance matter.
So let's just move into payment problems and, protecting your right to get paid, right? Because I mean, everybody wants to get paid. So, how do you structure payment schedules to avoid a lien or threats like on a homeowner pushback? So this would be, strictly residential. Is there something that should be in the contract that should state exactly like a payment schedule? And how should that be implemented, I guess?
Yeah, so on those, it's always be as explicit as you can possibly. If I'm structuring out and I want to avoid a lien, my big thing that I've got to deal with on that is one, what's my cash flow look like? What
Okay.
am I accountable to my subcontractors for? And
Okay.
then mark out milestones with your client. If you're worried about cash flow or anything that says, hey, by this date, we'll accomplish this, that's a money triggering event, and then we'll pay it out. Because the biggest problem you're going to have is somebody saying, I have an inspection obligation where I can actually control these flow downs, or hey, this wasn't done up to my standard, therefore I'm not going to pay you. Now your subcontractors are getting shorted, and the last thing you want is a mutiny of your subcontractors.
Okay.
So I always say that the big thing you're doing on that, be overly clear as to what's a payment triggering event and try to keep that feed going. Um,
Okay.
Because if you really do want to avoid it, I've had this issue come up with a subcontractor before. They didn't like their payment schedule. They let their costs run out. And next thing you know, the sub to a sub said, we're going to stop work. And now that forced the sub that I had to issue a stop work as well. And it all compounded and rear ended itself, which was just absolutely terrible.
But, managing delays, scope, and change orders. I mean, we touched on it a little bit. Legal best practices. You're in the middle of a project and you do have a contract, and the homeowner just decides that they want to add something. They've decided that, I don't know, they just decide they want to, add something additionally. So, how would a contractor go about implementing that change into the existing? Would it be an addendum or how would that be done?
Yeah, so two paths forward. There's an addendum. Most common idea.
If someone has a change like in the middle of a project, resident, homeowner wants to add something, what would be the best practice for the contractor to add this work into their proposal or scope of work or contract?
Yeah, so the best answer for that is never say yes right up front. Never say, yes, we can do that.
Okay.
And that is simply not only a CYA, but it's also speaking to whatever you do, don't break the contract you've got. If I have a material deviation and we're adding, that means I might be missing something of what's in writing. But then make sure you're not going to impact or crowd your subcontractors or make other issues for yourself. That's why I
Okay.
say, hey, I'll take that back to make sure it's something we can do. I want to make this happen for you. Now you're the enabler, you're not fighting against them. But if you have some kind of material change to your money, your schedule, or anything, take that second to realize you've got a sale in your hand. Now it's just about delivering it, but deliver it correctly. Don't do it in a way that'll hurt you. You mentioned earlier kind of the fixed price contracts and everything. That's where they're the simplest contracts in the world, but they're also some of the worst for you insofar as you bear the risk as far as the service provider, where, well, if I control my costs, I find some efficiencies, I can make more money off this. That's great. The customer gets an assurance of the price is the price. Problem is when you start deviating within that, well, now I'm eating margin. Maybe I'm losing something. I've seen some companies try to say that we're going to do fixed price and you have to open the book so I see what your profit is. And I've been like, absolutely not. You can't be that insane. My profit is my profit. My price is my price. Uh, so on those changes, it's, one, make sure you've got a change order procedure scoped out in your contract. But two, never say yes on the spot. go back and check to see what the cost of yes is. And a lot of contractors really make that mistake of trying to be people pleasers to get the good review. And they're going to wind up eating some costs because they didn't check to see what the cost of yes was.
Right. So this is a question I have. So how can, a simple extra work, the client, which is the homeowner, they're going to think, well, I just wanted to add maybe a 4x4 piece of concrete on the end of the steps at the end of the deck. I mean, it's just a concrete pad. So to them, it's a simple scope of work. But what is the risk of doing that, like without the paperwork and turning into a lawsuit, right? So the question is, how can a simple extra work without the paperwork snowball into a lawsuit?
Yeah, so I always say the lack of paper shows me a lack of due diligence. I live in an HOA where everything's got to be written, approved, and gone through boards. The moment I start to deviate from what we agreed to, if I run into an HOA problem, that might be that the wage is rip it out. If I run into an issue where a change actually altered the scope of the contract that I originally performed on, insofar as say you wanted me to do a bathroom and it was to have one tub, one shower, but the deviation was you wanted a wet room. Maybe you didn't want the tub in there, you just wanted more space. Well, great. We went ahead and we did it. Maybe there was some cost impact, but the homeowner goes back and says, under the contract, it said X, Y, and Z. You didn't give me these things. And that's where, and this has come up in my professional life quite a bit, so nobody gets a slap on the wrist for this one. The amount of times I've had to argue, sure, I understand you didn't get a signature or you didn't copy this thing in. I have an argument path under Uniform Commercial Code that I don't want to take, but I can get there. The number one thing I see is there's a material deviation from the contract, but you can still argue, well, clearly I wouldn't have deviated unless there was a promise for more money. So we're going to try to build out where that contract came into existence. But it's like I tell people, being an attorney, it's the cheapest insurance you'll ever get. Somebody to capture that, bring it all down and bring it together, because you really don't want to get into a dispute and then pay an attorney to try to fix it. We're
Okay.
very expensive. We're very cheap insurance.
Right. So I guess best practice, always put everything in writing. Never agree to do any type of extra work and don't give a yes right away. Is that
Exactly. If it's
your
not in writing, it doesn't exist.
right? Okay. All right. So you heard it straight from the attorney. If it's not in writing, folks, don't do the work. So that goes to that brings us like to the next topic, which is defects and warranty risks. So what qualifies as a defect and how do you protect yourself through the warranty language? So how do we know if it's actually a defect, and if you warranty your work, how do you make sure that you're not being taken advantage of or that you're being accountable if something does go wrong?
Yeah, so warranties are fun creatures because you can disclaim certain of them. There are some by law you can't disclaim. And if you put in a contract that you are okay with some, but not others, you have to be abundantly clear with that. So that's where warranties become gremlins. Now, I want to answer your question first of what's a defect, and then we'll go to warranty because they tie in. And a defect can be one of those things where you either made a mistake or the product has an issue with it. So they can
Okay.
be either latent or manifest. Latent defects are really, really terrible insofar as, say, you bought material you thought was on the up and up that turned out to be below grade. That might have latent defects because maybe it doesn't have the testing, it hasn't been put through the right kind of scrutiny. And then when that fails, well, that's where you have your forensic examiners come in for like insurance and things. And they say, okay, well, this needed to be of this product grade. And then in your contract, you warrant. It's usually called the warranty of like workmanship. It'll be the
Okay.
love like work up to the standard, etc.
Mhm.
That's where you wind up in that problem of vet your supply chain very closely to avoid those defects. Some things, if they're critical components, when I was working in oil and gas and building a company that was building refineries, one of the big things there is we had suppliers who didn't want to indemnify us and they were giving us critical supply pieces where, hey, if your product fails, this whole thing blows up and people get hurt. So no, we're not going to have a discussion where you get out of it indemnities because you don't like them.
Okay.
Reflexively for us, what we would say is, sure, if we install the component incorrectly or we kind of mess with it in a way, then yes, we'll void that warranty on your side because it's an implementation. And in construction, the same thing's true. When you're writing your warranties, make sure one, anything you're signing up to, you've vetted properly. there's something to be said for knowing your suppliers, knowing them well, and knowing what they'll insure you with. But on your warranty side, make sure you're crafting those that, hey, if there is an unexpected integration by my client that I wasn't expecting, that's going to void my warranty of merchantability, habitability, those kind of things. Of I built you something to spec that we agreed upon that I said for the standards we've expected these were. But I mean, no doubt you've seen it, Sonya. How many times have you given something a product or a deliverable and it was under one set of pretenses and then they've taken it outside where it shouldn't have been, it broke and they got mad? It's like, well, that's because I gave
Right.
you this suite of services, not that because you asked for this.
Right. Yeah. So you do have to be careful because you don't know what the client may or may not have done. Let's say, they purchased something that's not supposed to be in extreme heat. And maybe their air conditioner went out in their house. And now, the floors are buckling. And now they want to come back on you, trying to claim that it's a warranty issue or a defect in the tile or the flooring when, in fact, they didn't have air conditioning in the house for months. And, that's what caused it because the flooring's not it's not designed to be, under that type of pressure and that type of heat. So,
Exactly.
yeah, so you have to word things correctly. So, with that being like the verbiage, what language should every contractor use to set limits on defect liability and client claims? Is there a certain language that should be used?
So without practicing law to an entire group of people who may be listening, I can give you kind of an academic answer.
Okay. All
Um,
right.
However, you're drafting these kind of things, set a reasonable expectation for how long there is to discover a defect.
Okay.
I always say time bar when you can is going to be your best friend. If it says that you have to inspect it, that generally I like to shorten the windows. Because if you're going to be putting something through inspection and scrutiny, well, then your ability to actually detect defect or say I'm the buyer and I bring in some kind of home inspector or something to say this is good, this isn't.
Mm-hmm.
Now I've kind of taken that affirmative step of, well, no, I wasn't just waiting to see if your product failed in a certain amount of time. I affirmatively went to see somebody to tell me whether or not it would. So you can take some heat off and say, well, blame your inspector if they missed this, but we provided it up to our code and standard. And then as far as limiting your warranty liability, always try to account for the fact that law says you judge by the reasonable person standard. I've yet to find too many reasonable people. So you want to make sure you hedge in those as well that says, hey, based on your integrations, you can void the warranty. Never be out there with a naked open-ended warranty. So
Okay.
time bar for your defects, understanding you generally can't write out your latent defects. Those will be a problem. But time bar for express defects or manifest ones, and then limit the warranties, put where the breakers show up.
Okay. All right. Yeah. All right. Well, that's good to know. So make sure you have a timeline on it. So let's just, go into maybe some insurance questions. Because I want to know what is the hidden risk? Like if a subcontractor is in your home and they actually do some type of damage, um, can they actually claim that like on the homeowners and like make the homeowner responsible? How does that work? Or is that going to be something in the contract where, if they damage something, that's going to go on the contractor's insurance? And how do you navigate between the two?
Yeah. So in the fun part in construction and a lot of kind of supply chain work is I always say it winds up being a daisy chain of liability, right? Where if I'm the homeowner and I wouldn't know my contractor from his subcontractors from the next guy who wanders off the street. So from the homeowner's perspective, the service agreement with my contractor needs to essentially have an express provision. You break my property, you fix it. You put it back to what it was. Then if I'm the contractor, I need to look at my subcontractors and flow that same thing down. You harm the premises, you are going to step in my place and take the bullet for me. So that's where those indemnity provisions really daisy chain down. Now,
Okay.
that's where I say, I will never negotiate away premises liability or indemnification for damage to property or person from anybody who's gaining physical access under me. Because if you're the contractor, that's what will kill your company. You'll have somebody who can't distinguish kind of if it's a sub or if you're the primary contractor. And to me, you're all jointly and severally liable and chasing after you. And you guys sort it out on the back end. That's the entire scheme of indemnification.
Right. Okay. All right. So the next thing I'm going to bring up is licensing, permitting, legal compliance, because we all know there are contractors out there that maybe aren't licensed to do certain work. And then there's homeowners that, are trying to get something done cheap so they don't look into these things. So let's talk about, licensing for a minute. And if a contractor is not licensed, I mean, can it void the homeowner to pay them or trigger lawsuits? Like, how does a homeowner or the contractor go about making sure that they have all of the licensing and permit that is required? So let's talk about it from the contractor for a minute and then from the homeowner side as well.
Yeah, so from the contractor's perspective, a real risk if you're performing these services unlicensed is really going to come down to hold yourself out as licensed or not, right? The handyman versus the actual licensed, insured, bonded professional.
Right.
If you have a fraud issue and somebody's using that for price inflation, if I say I'm a licensed electrician and I come in, I think the last time I tried the wiring, I almost blew myself up because I wired a circuit that didn't have its breaker on. Yeah, there's a reason I paid for this.
Right.
You can wind up with market adjustments. It said, hey, this is a fraudulent price. This contract should be, but for fraud, significantly cheaper because I'm not paying for the licensing. I'm not paying for that standard necessarily. So from the contractor's perspective, really you kind of have this one, business reputation. Get hit for fraud. That's pretty awful. Two, then you have kind of this pricing adjustment where you're holding out services to the public. You have market rate services for handymen, licensed and insured individuals, and even the bonding side of it too. So those things all kind of raise the price that the consumer pays, but also as your business, you have this long tail of liability that comes through. Your insurer or your company might want to have a couple conversations with you too, because now your insurer is going to worry about what your warranty long tail is there because you're not using licensed people, maybe don't have training and certs. Now, as an insurer, you are maturing riskier because you're not vetting your workforce. So from the actual company side, you can take it on the chin up here on price, but next thing you know, you're back at overhead costs.
So what would you say? I mean, even in the smallest of jobs, I mean, just the smallest job, what's the biggest legal risk when a contractor actually works unlicensed, even on the smallest job? What's the biggest risk?
I would say probably your insurer dropping you or your insurer having those kind of issues. That's your coverage, that's your overhead, that's your bread and butter. Really, at the end of the day, I think your biggest risk there is, I'm not trying to figure out, think through if there's any others, but I really don't think there are, that your insurer does drop you because if I'm not licensed to pour a foundation, like add that concrete slab, the next thing you know, it's got issues cracking or running into other parts or peeling my customer's property. My insurer is going to look at it and be like, well, did you do your due diligence here? You're engaged in the service. My insurer is not going to step in to cover the costs of my mistake. Now I just have to average out. And so I really think it is. You start.
Okay, so you could actually lose your insurance coverage.
Or at the very least, see your premium skyrocket by the fact that your insurers now can start knocking questions around asking what you're doing.
Okay.
And then they'll have, if I prove I have a claim against my insurance, then maybe I'm not going to pay out because you're out there just living it. And that's not when you're doing your insurance certifications. That's not what you're doing.
Okay. All right. Interesting. Okay. Well, let's just go into dealing with difficult clients. We've all had them. We know you can do the best work, and sometimes people they're never going to be happy. They're always going to find something wrong. I mean, there's just those kind of people out there. So when a contractor gets into that situation, why don't you tell us some strategies that contractors can use to avoid, going to court if they do have difficult clients? I mean, what's the best way to handle that?
Yes, multi-layer your approach, right? In your contract, you want to make sure that you have clearly delineated what's a material breach or material defect and what is minor. Because generally, courts don't want to deal with minor defects. That would be, oh, I was told I was getting a brass fitting and you gave me a cast iron fitting. Well, there's no point in litigating that. This is pretty low effort. Make that a pretty easy escape route. The second is a dispute resolution clause, making sure those have fallbacks in your contracts. I always say my first 60 days, if I have a dispute, is an authorized representative of the customer and an authorized representative of the service provider. They'll take 60 days to hash it out. If they can't, then we'll look at going to court. We're going to do it in a bench trial. And I usually say, everybody,
bears their own attorney's costs that usually see if you pay. But you take that 60 days to kind of cool the heels. And to your point, what I really appreciated in our negotiation seminar we did is there's so much that you get just from that open, honest, and transparent approach up front that one by goodwill, even with a bad customer, and it'll allow you to kind of smooth these things out. There's no customer dispute that's as good as being proactive and being communicative. I've found even in dealing with people who are about to get sued or deal with sets of liability, by letting them know, hey, this is coming down the pike, here's how we can do it, here's what we can set up for, kind of here's the conditions you're going to have to follow up on. People actually appreciate that to the point that it smoothed everything out. Now, some clients, yes, they're going to say, well, this brass fitting violates my entire contract because I wanted these products. And some people you'll just never placate. And that's why I always say your first couple lines of sets are pretty aggressive contract. It says, that's a minor breach that most of it is.
Right. So what I'm understanding that you said, just make sure there's a structured dispute resolution like in the contract, whether, mediation, arbitration, bench trial, whatever it is. And I mean, and then sometimes just giving space, right? Like just letting that 30 or 60 days run and letting everybody cool down. You can actually come back to the table and talk through it and communicate through it.
Yeah, and the remedies clause in your contract will never hurt. Courts usually will enforce those pretty well. They'll say you agree that you would limit your remedies to these, like maybe 3 or 4 things. So that could take you out of the realm of what's a breach, then have all these other costs kind of at the tail end. Yeah, multi-layered approach, give yourself as much protection as you can.
Okay. All right, good. All right. Well, moving on to like subcontractor and supplier agreements. So, what's a clause contractors should include in their subcontractors agreements, because maybe they're relying on suppliers to, for materials or, whatever it is, their supplies. So let's just talk about, supplier agreements. Is there anything that you want to touch on, when you're purchasing supplies from a third party?
Yeah, so the big one I've usually seen from the government contracting industry is nature. But that's kind of small potatoes. The big one that I really got far too familiar with happened between about 2020 and 2022. We all remember those times.
Yeah.
Force majeure clauses. A lot of people decided to start litigating those when supply lines freed out. Next thing you know, suppliers could deliver on time. There were all these delays, and there was actually, and there still is, a live fire question as to whether or not something like a global pandemic is a force majeure event that will excuse people from the contract. So it's one of those things. I think almost every attorney almost looks at it as a throwaway because there's almost never some kind of natural disaster or problem that creates an issue. We saw 2 years of that we're arguing to get at a contract completely. Typically with these clauses, you'll want to make sure you have every obligation to still try to perform, find a way to do it. And if there's a modification that has to happen to do it, anything other than just using the supply. So force majeure is a big one. And I mean, it wasn't even just out of COVID. It was when that shipping container went over.
Yeah.
They're pushing Ukraine, that's installed on supply line kind of stuff. Maybe it's just the world's getting weirder. Laws finally seeing it. Right.
Yeah. Well, I remember I was on a project and it was right after COVID. I mean, COVID was a really bad time. And I mean, you just couldn't get materials. And we were doing a project. And I mean, there was an HVAC unit that was going to be, it was like 6 to 9 months before we could, get the units. And there was nothing we could do about it. I mean, I don't know if they were sitting in a container over in China or, wherever they were coming from, but it was a real problem. I mean, it was a real problem. I think we've kind of recovered from the COVID, situation with the supply chains and, things are much better, but now we're dealing with costs. Now you can get the supplies, but it's 3 times what it was, 4 years ago. So inflation's really causing a lot of, inflation. I mean, just the price of everything has gone up so much. At least in my experience, it has gone up quite a bit. So, yeah. So this has been interesting. I've really enjoyed it. But now I'm going to ask you some fun things because I want to talk about AI a little bit. And I'm just going to go into saying that I have used AI a lot. Now, not for legal, okay, not for legal aspects, but when I was a site superintendent, I built my own AI agent on Chat GPT that help me with project management or help me, create 3-week look aheads. It helped me track things. It helped me find specific answers that I needed if I had to go through a spec book that was about that big and I was looking for something specific. Back in the day, it would take me maybe days, weeks to find an answer. And now with AI, I can literally upload the entire document and I can ask questions. And I can find it just instantaneously, like instantly. So let's just talk. Let's get your opinion on AI overall. And then let's talk about it, on the legal aspect of what to do, what not to do, what's okay to use. And, let's just get your thoughts on the whole AI trends. What's your thoughts on it?
Yeah, so it's something a lot of attorneys have kind of been in denial about for a while. The idea of this is going to replace first year associates or transactional attorneys and things like that. And I used to be one of those people. I'll readily admit that. Used to say, absolutely not. It's not going to replace anything. The human element is completely. And then I set my practice up.
Okay.
And I've used AI to help set up my marketing campaign, get my content schedule going, even to inform me a little bit more on a couple other things. Now, I will always caution a lot of people who are adopting AI and push for it really takes this weird approach of lack of skepticism and then the fact that you kind of use it like Google. And it really is. If you're specific in your prompts and you can cultivate it, you know how to use the tool, it's fantastic. But having said that, the legal arena is dealing with this interesting problem where they've got attorneys who are getting sanctioned because they're using AI to draft AI cases, precedent, rules, and judges are catching it. And then those attorneys are getting able to find, interestingly enough, an Arkansas judge recently who issued one of his clerks, the judge signed it, issued an order that was generated by AI that elucidated parties, facts, claims, everything else. And there's actually no force against the judge for that. There definitely is for judge down to the attorneys, but not towards the judge. So we're entering this place where are losing their skepticism of AI, and very influential professionals are now using that hallucinated bad product into things that are going to affect everybody. So I say AI as a tool, fantastic. It's automated so many things in my practice. It's allowed me to get much more bang for my buck in my advertising. Coming up with just different content ideas. But the one thing I caught it doing, kept referring to me as Brandon Davis PLLC. After I kind of reviewed my website, I'm like, where is that represented? It's not held out. I had extensive training with my Chat GPT, and I still can't figure out my business entity. And it offers discounts for everything. I don't know why it's the idea I should make money. So I'm an AI believer insofar as being an AI skeptic helps you round out where it's got to go. But like any tool, right? I wouldn't show up to surgery with a hammer. Definitely not right. As far as tools, GPT is good to get a start. I've seen some horror stories, but I've had it draft a contract for me just to see how severe my job was. I saw a friend use one for his company, and I begged him to let me redraft it because AI was cutting a lot of clauses that were really against his business and applying other clauses that have pulled through the internet and just applied to his business. And then, you said you don't use it for legal. I wish everybody was skeptical as you all know, right? Use the tool correctly. But yeah, am I dealing with that? Use ChatGPT. I like where Gemini's going.
I like the deep research on Gemini and not to interrupt you, but I really wanted to say you hit the nail on the head because it's the prompting. If you know how to use the tool, you can get some amazing answers. You can definitely make some shortcuts. You can make your life very easy. But if you don't understand how to use the tool and how to really, use the prompts to get the best answers possible, you could get yourself in a lot of trouble. But I think for research, it is so valuable. So even if, I'm not using it, say, to draft a legal document, boy, I can find out so much valuable information, and maybe give that to my attorney or vice versa, right? As an attorney, you can use it for your research, but you would never want to use it to actually draft a legal document.
Yeah, any attorney turning to AI needs to take that step. And anybody who wants to give AI generated content to their attorney, because I'd yell at them for doing it to me, is always make sure the prompt and cite your sources for each piece, because some people will just kind of let AI go through. When it comes to, like, I like Gemini, particularly if you're filling out your like business profile, where
Okay.
basically telling Google your algorithm changes too much. So Gemini is great for that, kind of tell Google to tell itself. On GPT, I like I think it's version 03 that they're using for the deep thought that does. And then for just kind of broader research, this is just the commercial models. Perplexity and Claude are
Yeah.
there's something Claude is excellent at getting them started and capturing your voice. Perplexity is really good for deep research and citation. I've kind of been tempted to switch over to Perplexity, but honestly, I've spent enough time with ChatGPT. I feel like it owes me. So that's kind of where I'm at with that problem.
I know. I have my Chat GPT so trained because I have so many different agents that I use for different things. But I have used Perplexity in it, and I did use it when I had a legal issue that I was doing research, and I found that that worked really well. Claude is exceptional for blogs and content writing and proofreading and citing citations. I mean, it's amazing. So, yeah, I think that people need to be a little bit more open minded. It's great for automations. Now with AI calling, and there's just so much that can be done. But let me just ask you, so what should small business owners be cautious?
Sorry, I faded out there real quick. This question, what should small businesses be skeptical about?
Oops. Yeah, what should be most cautious about when when it comes to AI? I've just got a few questions. One of them was what should they be the most cautious about?
Yeah,
Anything?
I would say most cautious about their trust. Blind faith in AI is the one thing I see gets dumped pretty frequently, and it's just the unthinking, like, oh, this is inherently the smart thing. It's learning with Lord knows we're out here in Northern Virginia, all the data centers powering all these things to teach it to learn. But the number one skepticism is be skeptical about what's coming back and source it itself for you.
Okay.
And then when giving you authoritative links, that's perfect. My wife and I, we like to laugh at AI prompts where, somebody's asking how to get a better cheese bowl on pizza because these models are pulled from things like Reddit. One of the number one suggestions that Google's AI gave was to add sugar to your pizza. I don't recommend it. I like to cook. I don't think that's the way I want my cheese bowl. I'm adding glue to it. AI's guardrails are still going up. So I think force AI to prove itself. That's the number one thing.
Okay. All right. I had a little notification. All right. Well, yeah. I mean, like I said, I've used AI. I like it. I use it. It helps me a lot. But again, everybody needs to be cautious. So I'm just going to go through a little checklist and then we're going to just close this up. But, all the things we talked about, let's just, repeat. Don't ever start work without a signed contract. Number one, always put, your changes and your document changes in writing. Very, very important. Know your lien deadlines and try to enforce them. The other things we talked about, supply chains and insurances. Make sure you've got all of that covered really well. Is there anything else, Brandon, that you want to add that you feel like we left out that would be really important for a contractor or a homeowner that, might be looking to get some work done?
Yeah, and I think it's kind of the encapsulation that we talked about today. Your expectations generally leads to their satisfied customers, or at least non-confrontational ones.
Right.
That means those things in writing, define your scope, make sure you show what your left and rights are, and set your expectations all the way down. The point of a contract is just to remove ambiguity. So if you're not doing that, then you're missing something. To be honest, in my life, in my professional career, by being able to be honest and transparent, I've avoided probably 98% of potential litigation consequences. So whenever you're interacting with the public, I understand that's wildly unpredictable. Very
Right.
easy. super writing, you can really guard yourself. So just set those things clear. Say them in plain English. I hate that my profession is all about the heretofore and heretofore art thou. Just state, here's what we're doing, here's who you are, here's what that looks like.
Right. Well, I really appreciate you, educating us today. And for those people that might be listening, why don't you tell us how they can find you? What's the best way to get in touch with you if someone is looking for your services?
Sure thing. So I'm online at www.bdavisatlaww.com. Also, facebook.com/bdavisatlaww. I produce free content pretty frequently. There are blogs, videos on LinkedIn. It's Brandon Davis 417 will get you there. I'm actually producing 1-minute video explainers on key contract concepts and how it's kind of interplay. So some free resources available as I pull that out for your content site.
Well, that's great. Well, we appreciate your time today. And that's going to do it all for this episode of the Bold Vision podcast, Everything Construction. And today it was all about legal information and education. So follow us on YouTube and Spotify. And we hope to see you on the next podcast. Thanks for joining us today.
Thank you.
What?